Straight off the press, DC and Marvel just lost the rights to the word superhero. Hey, this is going to be exciting. You guys are going to learn a lot about this when we're going to get off into the article, break it down. And hey, I'm going to try to give you guys some tips on how you can avoid being in this situation that DC and Marvel found themselves in, because it's unfortunate. And I guess the question really becomes, is this the end of the superhero era? I am Dave, 10-year intellectual property, dealing with everything from copyrights to patents to trade secrets, as well as trademarks. Now, for those of you who don't know, DC and Marvel, they ultimately gained access to the superhero trademark in the 1970s. It's actually interesting. I was kind of doing some research before coming to you guys live. The first use of the word superhero was back in the 1917. And that was just, to describe a person, a public figure who had some great accomplishments. So if you were doing your thing, you're a public figure, had some great accomplishments, you were called a superhero. Then in about 1960, you had the first trademark of the term superhero by the Ben Cooper company, Ben Cooper Inc. They trademarked the term superhero in 1967 for Halloween costumes. Think of that. You think of public figures and action figures and comic books, and the first actual trademark of the term was for Halloween costumes. Then you had this battle between Ben Cooper Inc. as well as Mega Corporation, and ultimately DC and Marvel gets a hold to the term superhero, files a trademark for the term superhero. They've been killing it ever since. This was, again, back in the 70s, late 70s, when they start to trademark the term superhero for a number of different things and, come out with action figures and stuff like that. And again, up until this point in time, it's like, okay, are we going to see the word superhero used by DC and Marvel going forward? They don't have any rights to it, which is good for you and I, because we can actually use the term superhero without worried about getting sued from DC and Marvel. I was actually looking at an article, and I guess it was a college student, I think back over there in Europe somewhere, and he had kind of wrote a book called from Business Zero to Superhero, and DC and Marvel sued him. So again, they've been pretty active as far as filing suits to protect their trademark, which you have to do anyway. But they've been, really, really active in doing so. We're going to take a look at the article to see, again, what happened to cause them to lose their trademark. I'm going to try to give you guys some tips, because this could have been avoidable potentially if they had taken steps to not make the term superhero become so generic. And look, I have a friend, and we've been watching. Look, I'm generally, I wasn't a superhero. I was not a Marvel and DC guy, I would say. Again, I'm a big sports guy. Obviously, you see in the background, play football for the great University of Michigan State University. And again, I wasn't a big superhero guy, and I must admit that I was wrong. A friend of mine, they've been putting me on to these superhero movies, and we've been kind of doing the Iron Mans and the Hawks and just the whole Marvel universe. And I must admit, these things are pretty cool. So I think I was left out, but I'm glad that I'm on a bandwagon. But let's take a look here at this article that came out, and it's fresh off the press. It came out a couple days ago, and what is it? What is it titled? Marvel and DC just lost the superhero trademark. Here's what it means. Look, I already told you kind of what it means is that you and I can use the term superhero without worrying about getting sued. So to the extent that you have this action figure or you have this comic book and you want to use the term superhero in the title, you want to call one of your action figures, some name followed by superhero, you can do that according to the latest decision by the United States Patent and Trademark Office, a federal court. You can do this without being sued by DC and Marvel. It's kind of crazy how they kind of came to the decision, but let's get off. So the U.S. Patent and Trademark Office has shaken things up in the world of comics today, as a long-held trademark by Marvel Comics and DC Comics has now been canceled. The announcement comes courtesy of this law firm who have declared victory over DC and Marvel in a trademark case of the word superhero. The request was granted after DC and Marvel failed to respond to court requests over the challenge to the joint trademark. And now it has been canceled. Man, that's crazy. Look, just let me paint this picture for you guys. Let me paint this picture. So it seems like somebody petitioned the United States Patent and Trademark Office over DC and Marvel's trademark to the term superhero. and pretty much probably saying, hey, it's generic, which they're going to talk about a little bit more in the article, a little bit further down the line in the article. And the USPTO trademark has reached out to DC and Marvel to say, hey, man, we got this petition to say that your trademark should be canceled. One of your most well-known trademark superhero that you've been enforcing, like, left and right over the years, over the last, 50 years, you've been enforcing left and right, suing people. We got this petition to say that, your trademark should be canceled because of X, Y, and Z. Let me hear why it shouldn't be canceled. And according to this article, they didn't even respond. How crazy is that? You get a petition to cancel your maybe your most well-known trademark, and the court, the United States Patent and Trademark Office, is asking for your input, and you don't respond. And I think that's crazy. I don't know. That's crazy in my opinion. Again, and that's what it said. Look, the request was granted after DC and Marvel failed to respond to the court request over the challenge of the joint trademark. That's crazy. Let's continue on here. DC Comics and Marvel Comics registered the joint trademark of the world superhero in 1977, and it was eventually approved in 79. So I told you, Ben Cooper Inc., they initially filed for the trademark on the term superhero for Halloween costumes. Ultimately, DC and Marvel got rights to the term superhero from Ben Cooper Inc., as well as a Mega Corporation, and again, they filed for a trademark on it. Since then, they have successfully defended the trademark multiple times, both stateside and internationally, but a new challenge to the trademark was made in May of this year. The challenge was issued by Scott Richhold of Super Baby, stating that superhero, as well as the term like superhero are generic terms that aren't entitled to trademark protection. Look, let me bring it on. Let me bring it back on you guys. I continue to tell you guys, and I just made a video on this where there's 4 categories of marks, 5 categories. You have a generic mark, which is never protectable. You have a descriptive mark, which describes the nature of the goods and services, and it's not protectable at the beginning, but you can later on get protection of it if you can show secondary meaning, if you can show that the trademark, your descriptive name has acquired, it has become distinctive, in other words. Then you have suggestive marks, which are, you can't protect those terms from the beginning. And that's something that, when you think of when somebody gives you a name that's suggestive, it forces you to use some type of imagination to kind of figure out what the goods and services is. Then you have an arbitrary mark. Again, we know in my opinion, the most well-known arbitrary mark is the term apple. We know apple is originally meant to be a fruit. However, the technology company Apple has used it for technology products, and that hasn't been done before. So you're taking a term that already exists, you're using it for a different use. That's a arbitrary mark. And again, those are pretty strong. Those are actually stronger than suggestive marks. Then the last one is a fanciful mark, and that's probably up there with arbitrary as far as being the most strongest form of protection. And that is essentially a made-up word. A lot of these drug companies, they make up these names to these drugs. Those are fanciful marks. I heard that Twitter, you guys have to let me know in the comment section, that Twitter made up is a made-up word. And to the extent that it's a made-up word, that is another form of a fanciful mark that gets afforded the strongest protection from a trademark standpoint. But again, going back to generic, this argument from this gentleman, Scott from Super Babies, is pretty much saying that, hey, this term superhero is a generic mark. What do you guys think? Do you guys think that superhero is a generic mark? Again, generic marks cannot be trademark. They can never be trademark. Like I said, descriptive marks at some point can become a trademark, and suggestive, fanciful, and arbitrary marks can get trademark protection from the beginning, but a generic mark would never be allowed to become trademark. And what's a generic mark? It's pretty much, it's generically used to describe the goods and services. So to the extent that you actually, Xerox, they had this issue years ago of that term Xerox kind of falling out of trademark protection. So when you think of kind of back then, for all the old heads that listen to me, again, Xerox is a copy machine. And a lot of times, as opposed to kind of using it as a copy, using it in a trademark sense, people are using it to describe the actual, the thing that's being done, almost like an adjective, if I'm not mistaken, where they're saying, hey, just Xerox it. They mean copy it, but they're saying just Xerox it. There again, you can be talking about a copy machine from this company, a copy machine from that company, a copy machine from this company. But the fact that you're saying just Xerox it, it kind of makes that term more generic, because again, it's more so, it's not being used in a trademark sense. It's not being used to describe the source of the goods and services. Instead, it's become generically, it's more generic for the actual, I guess the actual thing being done, in this case, copying. So this guy Scott is pretty much saying, hey, man, superhero, that's not a DC or Marvel thing. They're not using that specifically to describe the goods, in this case, the action figures that they're doing. We all use the term superhero, but I'm assuming I'm talking about somebody who's strong and powerful, have super-like characteristics. And this guy is saying superhero, that's a generic term. That's not a trademark. That's not a trademark term that's specific to DC and Marvel. That's pretty much what their argument was. So let's see, bring it back on a article and let's see what it has to say. So the petition states that DC and Marvel are wrong. Trademark law does not permit companies to claim ownership over an entire genre. Again, when you're talking about generic marks, you're talking about a genre mark, entire genre. And they're saying, hey, and they're right. Trademark law does not permit companies to claim ownership over that. So if you go through the complaint, you will find find a host of examples from DC, Marvel, Image, and more utilizing as proof of the core point. Super Babies then asked the court for a default judgment in the favor and stated that while DC Comics and Marvel characters filed a motion to extend their time to answer the charges by the 24th of July, they had not done so or requested more time to respond. So again, it seems like DC and Marvel filed a motion to extend their time to answer, which it seems like that was by the 24th, and they still didn't answer. So what does this mean? Some comic books, man, I haven't read a comic book in a long time. I guess this is a comic book from the Super Babies. Let me know in the comments if you're a big what's the name with the Super Baby. Look, they already what's the name. They got the trademark that's been ripped up from the term superheroes. That's actually pretty cool. That's pretty cool. So this won't affect Marvel or DC as far as what they can print or use, but it does mean that they no longer have ownership of that trademark, meaning that other companies can now freely use it. So again, we can use the term superhero. We're talking about a comic book and we're talking about an action figure without the cause for concern of being sued by DC and Marvel. In a statement, lead counsel for Super Babies, Adam, said this is a win for everyone and make sure that the term superheroes has a home in the public domain. And I probably agree with that. This is a win for everyone. Securing this result is not just a win for our client, but a victory for creativity and innovation. By establishing superheroes placed in the public domain. So that's what it means. The fact that it's no longer trademark, you can't get a trademark on the term superhero because it's in a public, because it is a generic term that puts it in a public domain so that we all can use it and benefit from it. So what they're saying, by establishing superheroes placed in a public domain, we safeguard this symbol of heroism available to all storytellers, which I mean, it's hard to argue with that, I'll say. Superhero stories teach us to stick up for the little guy, so it's only fitting that the liberation of superheroes will come after the hands of the Super Babies. And that's funny. That's funny. So, I mean, again, what do you guys think? What do you guys think? The term superheroes is in a public domain. You can use it. I can use it. This is not a term, a trademark this is no longer a trademark term that's owned by DC and Marvel. And look, I was telling you guys that back in the 70s, DC and Marvel acquired this term from Ben Cooper Inc. And I know Ben Cooper Inc. like, whew, I dodged a bullet. Just think that you sell a trademark to someone and 50 years later, the courts decide or the USPTO decides that you can't even have a trademark in that name because it's a generic mark. Talking about dodge a bullet for the Ben Cooper Inc. But again, he still got some money. And I guess this is a teaching moment that I want to bring to you guys' attention. Number one, when you're using your trademark terms, make sure you're using it and you're almost telling others to use it in a trademark sense. You don't want them to kind of use your trademark terms to generically or generally describe something such as, hey, go Xerox it or go Google it. Google had this issue as well. You don't want people to be saying, go Google it, meaning go search it, whether you're using the Google search engine or another search engine. You want to be using your term, your trademark term in a trademark sense. And that is to describe the goods and services of your company. So to say, hey, go use Google to search that, whatever. So you're saying, hey, go use Google, which is, again, is a platform that you can use to search different things. So you're saying, go use Google to search that, whatever, as opposed to say, go Google it, because you don't want your trademark term to become synonymous with, again, in this case, searching going to say go Google it, that means it's okay, going to go search it. You want to say, hey, go use Google, which is again the trademark term, the trademark brand name, to go do your searching. So you want to be able to use your trademark, your terms, your logos, your phrases in a way that it pretty much is being used in a trademark sense, as opposed to generally describe I guess the thing that you're trying to be done. So that's what you really want to do to try to avoid your situation, a situation where now your trademark is looked at as being a generic trademark, and it's being in the public domain, and the USPTO is coming knocking at your door to say, hey, let me get that back. That's not a trademark term. That's a generic mark. And generic marks are no longer, are not no longer, generic marks aren't protectable. So hopefully you guys got something out of this. Again, make sure you're using your trademark term as a trademark and not generally as a generic mark. Make sure you are encouraging others, your consumers and other people out there to do the same. And yeah, hopefully you guys got something out of it. Too bad for DC and Marvel. I'll still be kind of finishing up on those series, though, as far as kind of looking at those movies. And again, this is definitely a win for you and I, being able to use the term superhero for our comic books, for our action figures, things like that. So hopefully you guys got something out of this. Please hit the like button if you did. Please subscribe to this type of to the channel if you haven't already. I'm trying to give you guys this, not only the entertainment aspect of it, but I'm trying to provide you guys value, and hopefully you guys got something valued out of this one as well as the entertainment. So please hit the subscribe button if you haven't already, and I'll catch you guys later. Peace.